day, everyone. This is your teacher, FB Angid on air. This time, we will be discussing about the rules of court. Where can you find the rules of court? Of course, under the remedial law. So, what is the remedial law? It basically refers to that particular law which is being used by lawyers, by the courts, to find remedies or solutions to every problem or complaint or situation, incident that needs to be resolved and was brought into their attention. Okay. Now, there are salient features of the rules of court that I wanted you to take the notes in relation to our topic in the subject, which is technical English. There are two rules that I wanted you to note, which is Rule 14 and Rule 21. These are remedies that are available to everyone who wanted to make use of them. Now, what are these? This is in relation to quasi-judicial documents. This is the rule on subpoena and summon. Now, what is subpoena and summon? These are communication letters that are being furnished to someone who is being invited either to testify on something, to present a document, to give testimony, or a person is invited to at least make clarification on some issues that he is being involved to. The question would be, what is subpoena and what is summon? Are these two terms similar with each other? If not, then how do they differ? When are these two documents being issued, and who will prepare them? If it is being prepared by a particular person, who will serve them? And to whom are these communication letters being directed to? Okay, to answer those queries, let's go to the limits. What are the limits of Rule 14? What are the limits of Rule 21? Well, Rule 14 of the Rules of Court talks about summon. On the other hand, Rule 21 of the Rules of Court talks about subpoena. So what you are looking into is the difference already between the two rules or the two terms, summon and subpoena. So how do they differ? Now, we understood that the term summon is different from subpoena. Why? In the first place, there are two rules, different rules that govern them. Summon is governed by Rule 14, while subpoena is being governed by Rule 21 of the Rules of Court. Okay, to whom are they directed? Well, of course, for summon, this summon is being directed to the defendant. So if a particular document, a summon, is being issued, the addressee, the summon or the letter must be directed to the defendant, not to the complainant, not to the victim in a particular case, but to a defendant. Summon is usually being used in civil cases. That is why they used defendant instead of respondent. That is to emphasize that this document is generally used in civil cases. The summon shall be issued to the defendant. On the other hand, subpoena is directed to any person. Take note of the difference. Okay? Subpoena is given to any person who has part in the resolution of a particular criminal case. So subpoena is a term that is used in resolving cases which are criminal in nature, which is a crime in nature, I should say. Okay, so summon for civil cases and subpoena for criminal cases. Although these two terms are being used interchangeably sometimes. So summon is being directed to the defendant, and subpoena is directed to any person who has any knowledge or participation or any part in an incident or in the resolution of a crime. Okay. The summon is being issued to the defendant to invite him or tell him or notify him that he needs to answer, okay, a query or a complaint that is filed against him within the given time. Again, I would like to emphasize the word given time. Okay, this you can measure that time again is of the essence. It is very important for us to know when are we going to file our answer, because if we filed our answer beyond the time given, the result will be the grant of relief to the other party. Yeah, okay. Well, in fact, if we talk about subpoena, this subpoena is being directed to any person, as I have said a while ago, who has a part on the resolution of the criminal case. And this is somewhat an invitation to that particular person to attend the trial and offer his testimony in court, either by way of testifying or by way of producing documents or something that corroborates the claim or that could be used as an evidence in the resolution of a case. I hope you understand that. Okay. Now, in summon, I have told you a while ago that you have to give your answer. If the summon is given to you as a defendant, you have to file your answer within the time given. Otherwise, if you fail to do so, what will be the result or the consequence? The court will decide in favor of the complainant. The relief that is being prayed for by the complainant will be granted by the court. Meaning to say, you will lose now your right to defend yourself because of your failure to answer or to file your answer within the reglementary period. Reglementary period meaning to say the prescribed time that is given to you by the court. Now, in subpoena, if you fail, okay, to appear before the court when you are being subpoenaed, this will result, first, you will be held in contempt of court. Next one, you will be arrested. An arrest warrant will be issued against you, okay, so that the court can order the police officers to arrest you and bring you before the court to answer the query, why did you fail to testify or to appear personally when you were called to do so? Okay? And when you tell a lie, of course, you will be held in contempt of court for not following the instruction or the order of the court, and perjury will also set in. Contempt of court usually is being issued when you cause the delay, okay, of the service of the subpoena. Like, for example, if the sheriff will go to your place to issue or to serve the subpoena, you are inside your house, but what you did was to let your housemaid, okay, to take the subpoena. And of course, the sheriff is not going to give the subpoena because the subpoena shall be received personally by the person, okay, whose name appears on that particular document. So there is failure of service. The subpoena was not served to you personally, and it is found out by the court that you caused the delay, that you intentionally did not appear during the time that the sheriff eh, is going to serve someone, even if you are actually present. That delay, eh, that act will lead you to be in contempt of court. Meaning to say, you will be penalized, you will be punished for not following the order of the court for you to appear and testify or bring an evidence before the court during a trial. That's the uh, result or the consequence of the failure to follow uh, the subpoena. Okay. Now, how do we serve subpoena and summon? Well, there are two types of service of summons and subpoena. The same, they can be served personally. Okay. So in person, the sheriff will give it to the person to whom it is directed, and that particular person receive the summon and subpoena will sign the copy of receipt. There will always be two copies of that. The one is serves as a receiving copy. Okay? And when you sign that, the sheriff or the person authorized to serve the summon or the subpoena will bring that back, okay, to the court as a report, and that is what we call return of service. Okay, return of service of the summon or the subpoena. You may have to make a return. Okay, now what about if you are not there? You did not intentionally go away, but at the time that the summon or the subpoena was being served in your in the indicated address, okay, on that particular document, you were not present. We have what we call substituted service. This could be received by a person authorized by you or a representative of you. Like for example, if you're a couple, if you're not present, your wife may take it or may receive that particular document in behalf, on your behalf, in behalf of you or on your behalf. Okay? So personal and substituted service can be done. The only difference is that in summon, since the summon is directed to the defendant, okay, there is no remuneration or fee that is being given. While in fact, in subpoena, since the subpoena is being directed to any person, so it could be a witness, then the service of summon may be accompanied by what we call a kilometrage fee. Like for example, we need your testimony as a witness to a murder case. Well, it costs you money to come to the court and present yourself and testify in court. Okay? It would entail your work if you are an employee. Like for example, if you are a security guard in a certain company, okay, and here is a subpoena issued to you because you were once a witness to a murder case. So since it is a subpoena and you know that failure to appear before the court, okay, will result to a contempt or may result to your arrest, you have to obey the order of the court to appear in the trial. In that case, you will lose your salary in that particular day in your work. That would now justify, okay, the payment of 1 day kilometrage fee to that particular person. So, if the sheriff is going to serve you the subpoena and you are a witness, then that subpoena is accompanied by a fee. that would serve as your payment for that day, a payment of delaying whatever work are going to do, okay, in exchange of your time to appear in the trial. Unless, okay, the kilometrage fee may be waived in cases where the subpoena is directed not to a witness but to the principal actors of the case, or the principal actors of the case, the what do you call this, the defendant or the respondent, the accused, or the complainant. Because there are cases that when the case is already on trial, okay, either of the parties may get absent, and that would delay, okay, the trial. For example, the trial was set on August 12th, and here comes August 12th. Okay. During the trial, the complainant went abroad. So it is impossible for the trial to go on without the complainant present. Okay. So, class, in an actual scenario of a court hearing, before the court will start, the clerk of court is going to read the case before uh, the persons, or before the public who is present in that courtroom. He would be reading the case like criminal case criminal case number 2001, uh, Hinaro versus uh, Court of Appeals and People of the Philippines, May 24, 2022. Uh, and then the clerk of court or the judge, it could be the clerk of court or the judge himself, will ask, okay, is the prosecution or is the complainant present? Yes, Your Honor. Okay, so he is present. Is the defendant or the accused present? No. If the accused or the complainant is not present in that particular time, then the hearing may be delayed. It will cause the delay of the trial. Okay? That is why, to what we call this, to eradicate that scenario, they had given a kilometrage fee for the witnesses or other people, not the principal actors, to use and come before the court during trial. It is somewhat a what we call this, a pro bono payment for the priceless time of these people uh, to appear before the court. Now, let's go with alias summon, where the person, uh, where the what they call this, where the summon is being issued to a defendant, okay, and was served once, but the service is a failure, meaning to say that the defendant was not able to receive the summon in whatever reason, okay, so the service of summon failed, and the report of that failure was being made by the sheriff to the court. Now, if the court would like to summon you again, then they are going to issue an alias summon. An alias summon is a subsequent type of document. Okay? It is actually another summon, okay, that will be given to any person that would represent now the defendant. Because first, the summon is issued directed to the defendant. If the service of that summon fails and a return of service was made, the court may issue succeeding, or subsequent summon in a form of an alias summon. Okay? Yan, tawag natin alias summon. Now, let's go to subpoena. There is no such thing as alias subpoena. You do not have that. If there is an alias summon, there is no such thing as alias subpoena. Okay? We cannot just invite anybody to testify in court that do not even have a relation or knowledge on the incident or on the crime that is to be tried. Okay? So we cannot issue an alias subpoena. Because if the return or if the service of the subpoena is a failure and the return of service was made by the sheriff, the court issuing the subpoena will no longer issue another subpoena. What the court will issue now is either a contempt of court or an order to arrest that particular person who failed to follow the subpoena. Okay? So unlike in summons that the court is more lax, okay, more relaxed, more they are giving more leeway, okay, for the defendant to at least answer the complaint that is filed against him. Unlike in subpoena that you are being forced, okay, it is compulsory for you to appear because it is an order coming from authorities. Now, there is only one type of there are two types of summon, the original summon that we have discussed a while ago and the alias summon. Now, when we talk about subpoena, there are two types of subpoena, a subpoena de sesticum and subpoena ad testificandum. So what are these? Subpoena de sesticum actually is an order. It is a communication letter directed to any person who has part in or has a knowledge on the particulars of a criminal case. Okay. They invite him or serves as an invitation to this particular person to produce a document that is needed in the trial. Docesticum. Documents. So if you receive a subpoena and the details or the contents of the subpoena is an order for you to produce ledgers, to produce receipts before the court during trial, then those things or that subpoena is what we call subpoena docesticum. On the other hand, if in that particular subpoena you are ordered by the court to appear in a trial to offer your testimony as an evidence to the criminal case, then that is what we call as a subpoena ad testificandum. Okay? Testificandum, testimony. So you have to come and appear before the court to offer your testimony. Ad testificandum. You have to come to the court and produce documents that we needed to resolve the case. Subpoena docesticum. The court will issue subsequent summon in response or by virtue or on the basis of the failure of the first summon being served, then that is what we call an alias summon. So those are the things that makes the two terms different from each other, from the rules that govern them to the details. Now, let's discuss summon first one by one. Rules of Court, Rule 14, summons. It is the clerk of court who shall issue the summon, as you can see in section 1. Okay? So when should the clerk of court issue summon? Upon the filing of the complaint and payment of the legal fees. Okay? So there are two requirements for you before the clerk of court will issue the summon. First, that there must be a complaint filed against the defendant or the respondent, and when you filed that complaint, you had paid the required legal fee. Okay, so you have to pay a filing fee, what we call as a filing fee. Okay. So once you had paid the filing fee and gave the copy of the complaint to the clerk of court, then the clerk of court will issue now a summon. So what are the contents of the summon? First, as I have said a while ago, it must be directed to the defendant. So naturally, a summon will contain the name of the defendant, the signature of the clerk of court. Of course, that signature should be under the seal of the court. Name of the court, the branch of the court. If you say the name of the court, it means the branch, what branch of court is involved in that case. The name of the parties to the action, the name of the defendant, and the name of the complainant. Okay? The direction that the defendant, okay, shall answer within the time fixed by the rules. So there is you're going to tell in the summon that if the defendant is given from the time of the receipt of the summon 5 days to answer the complaint. Okay? So the reglementary period or the fixed time by the rules must be written in there. And of course, lastly, the notice that unless a defendant so answer, the plaintiff will take judgment by default or the case will be dismissed in favor of the complainant. And the prayer or the things that has been prayed for by the complainant will be given, will be granted. So what we call granted the relief. Okay? So a copy of the complainant and the order of appointment of guardian ad litem, if any, will be attached in the original copy of the summons. What does guardian ad litem means? Okay, it is the guardian that has been appointed by law. It simply means in English legal guardian. Guardian ad litem means legal guardian. It is somebody who has been appointed by the court to be the guardian of someone else. It could be a minor, could be a property. Okay? So the copy of the complaint and the copy of the legal guardian, appointment of the legal guardian, will be attached to the copy of summons. Okay? Now, to whom should a summon be served? Okay, it will be served by the sheriff or his deputy or other proper court officer. However, there are instances where any person authorized by the court issuing the summon may be able to serve the summon. But primarily, service of summon and subpoena is a task given to the sheriff. This is the role of a sheriff. The sheriff and his deputy or his assistant. It could also be done by court officer in case that the sheriff is not present. Okay? What about if the court officers are all busy and they do not have time to perform the service of someone? Then the court will designate a person, a capable person to do the service of summons. He should do so in accordance to the authorization given by the court, because without that authority, any person cannot serve someone. Only the sheriff and his deputy and court officers. Now, Section 4, return. What do we call the return? It's the return of the service of the summon. When the service has been completed, well, the server or the sheriff shall, there has been specific days, 5 days, serve a copy of the return personally or by registered mail to whom the lawyer or the counsel of the plaintiff, the complainant, okay, lawyer of the complainant, and shall return the summons to the clerk who issued it, accompanied by the proof of service. So here is a copy of the summons received by the uh, respondent or the defendant. That is what we call a return. Okay? A copy given, a copy of the return or the service served summons to the clerk of court who issued it. Now, there. When may an alias summons be issued? If a summons is returned without being served or any or all of the defendants, okay, then within 5 days therefrom, they will serve a copy of the return and the plaintiff counsel. If the summons has been lost, the clerk, on demand of the plaintiff, may issue an alias summons. So there are two instances when an alias summons is being issued. What is very clear is that an alias summons will be issued in case that the original summons has been lost. Okay? The clerk on demand of the plaintiff. So it is an option of the plaintiff to choose, okay, the person to issue the alias summons. Okay. Service in person to the defendant, of course, is very practicable. You just give it to directly to the defendant. Next one, substituted service. What is substituted service? If the defendant cannot be served with a reasonable time, okay, service of the summons may be done or effected by leaving copies of the summons at the defendant's residence, okay, with, of course, some people who is in the legal age to receive that, especially if he is acting in the capacity of a representative, okay, who is a person of suitable age, a legal age, a person who has discretion or discernment. What is discernment? A person who knows the difference between right and wrong. Okay? A person who is matured enough to know the consequences if he fails to perform what is being instructed in the summons. Okay? So that is what we call substituted service. A service of the summons that is not done directly to the defendant, but has been done to any person, okay, who is of suitable age and discretion to receive the document or the summons in lieu of the defendant. Okay, so service of an entity without juridical personality. These are companies. If you talk about juridical personality, companies, big companies, okay, has the corporations, okay, has the juridical personality. Service upon prisoners. If the defendant is a prisoner or is already inside the prison, because here in the Philippines, if you are being caught in a crime, okay, while the crime is being tried, is being investigated, you will be put in jail. Okay, you will be put in jail. So while waiting, how do prisoners are being served with a summons? They are being served with a summons through the initiative of their officer in charge to look for them. It could be the jail warden. So the court will issue a summons to a prisoner. It will be through the jail warden. Okay? Can a minor and incompetent be valid receiver of the summons that will be served? Okay? Well, of course, when the defendant is a minor, insane, or otherwise incompetent, service shall be made upon him personally and on his legal guardian. If he has no legal guardian, they must do, right? His guardian ad litem, whose appointment shall be applied for by the plaintiff. So it is the option of the plaintiff to look for a what we call this a guardian. Okay, so juridical entities, corporations, those are corporations. Yeah, service upon public corporations. You include non uh, government controlled, owned, or controlled corporations could also be included there. Okay, so service upon defendant whose identity are unknown. Okay, so if it cannot be ascertained by diligent inquiry, you have exerted all your efforts to know the whereabouts or the details with respect to the defendant, you were not able to find any, then by leave of court, okay, you may request for that, and it shall be effected upon you when it is published in a newspaper of general circulation. What is a newspaper of general circulation? This is a newspaper that is being read by the public. It is generally being circulated or distributed not only in a particular area but to all areas of the nation. Okay, now this one, extraterritorial service. What is an extraterritorial service? This is simply a service of summons out of the country. Okay, so when the defendant during the time of the incident is a resident of this country, but after some time went abroad, then he is no longer residing in the Philippines. Okay? And the action affects the personal status of the plaintiff. So what are you going to, how are you going to serve the uh, document, the summon? Okay? So by way of extraterritorial service. You go and serve it by publishing it in a newspaper of general circulation. It could also be so granting the leave shall specify a reasonable time. Okay, so those are the salient features of what we call the summon in Article 14. So I had made or presented to you a graph, a process graph or figure in order for you to understand the flow. So from the barangay level, there will be an application or request for the issuance of a summon against anybody. Okay. An example, if Marites and Mariposa, who are neighbors, had an argument with each other, and one of them went to the barangay and request the barangay should summon you for purposes of resolving the argument or the differences between the two of you, then it could be. So, in the Court of Appeals or in the court level, you file and pay for the docket fees. Okay. Now, the barangay secretary prepares the summon and the chairman affixes his signature. Well, ministerial. It's a ministerial duty of the chairman affixing his signature or signing a document. Okay, so it is also an inherent duty of the secretary that she must be knowledgeable enough to prepare documents that is being asked for by clienteles. Of course, after that, you serve the summons to the parties. Now, if you are talking about the court level, okay, then the filing and the payment of the docket fees is enough to warrant, okay, that the candidate or that the court will take or issue the required summon. So the court or the clerk of court, upon filing of the complaint and payment of the docket fees, will issue the said summons. And of course, it will be served either personally or in a substituted service of summons, and the return and proof of the service will always come after, just like a feedback. Okay, so below is the already an example of motion for the issuance of alias of summons. So an alias of summons may be introduced by a memorandum type or through a motion. Like for example, this one, it is through a motion that the alias summons was being issued. Okay, so that is Rule 14. Now let's go to Rule 21 on subpoena. Okay, so subpoena and subpoena desisticum, as I was saying a while ago. Okay, what is subpoena? Is the process of directing person to require him to attend before the court to testify what he heard, what he saw in an incident. Okay, or in this case, subpoena desisticum is that particular process directed to a person that would require him to produce documents that would corroborate the statements of anybody in the resolution of the case. So, to whom it is being issued? It is issued to the court before whom the witness is required to attend. Okay, so the deposition to be taken. Okay, so those are the salient features of what we call a subpoena. Okay, so I hope that you understand the discussion and do better in your studies. This is what I wanted you just to note. And now, as we go on, I would like to say congratulations for finishing this subject or this course under my supervision. So this time I would like to say good afternoon, good day, happy day. This is your teacher, FB Angit, signing off.